The critical issue here is the systemic failure of the portal, specifically regarding the missing forms.
That's right, and this directly affects the viability of any Supreme Court appeal.
The Supreme Court of New Zealand represents the absolute final word in the country's legal hierarchy. It is the apex of authority. When a self-represented litigant loses a dispute at the tenancy tribunal over a jurisdictional technicality, the immediate feeling is profound frustration. That frustration peaks when they attempt to challenge the ruling, and the Ministry of Justice's own online portal glitches and completely deletes the paperwork. The natural human reaction is to bypass the lower courts entirely. You want to take the grievance straight to the top, to hold the system accountable for its failures. The 2026 New Zealand courts do not process cases based on emotional validation or the perceived unfairness of a software bug. They operate on clinical, statutory procedure. Every filing must pass the jurisdiction test, rigid laws dictating exactly which court has the legal permission to hear a specific claim. Treating the Supreme Court as a generalized complaints department guarantees an immediate dismissal and leaves the actual underlying legal problem completely unresolved. Before a document ever reaches a panel of judges, it hits a wall of administrative gatekeepers. Under Rule 5A of the Supreme Court rules, the registrar holds the absolute power to summarily reject filings at the door if they fall outside the court's jurisdiction. That rejection costs the litigant a $468 filing fee and burns weeks of critical legal time. This creates a difficult dilemma. If a state system unfairly deletes your file, how do you force a correction without getting thrown out on a technicality? You have to master the unglamorous rules of statutory jurisdiction. Operating within those boundaries is the only way to convert a systemic grievance into an actionable remedy. The interior architecture of the Supreme Court is designed to feel restorative and community-focused. The legal boundaries it enforces, however, are entirely rigid. This flowchart maps the strict ladder of law. Appeals travel sequentially from tribunals through district and high courts to the Supreme Court. Watch a litigant try to bypass the middle tiers to appeal directly to the top. Section 70 strictly blocks that path. The law requires district court and high court review first. There is no legal mechanism to bypass those mandatory steps. The Supreme Court judges do not possess special inherent powers to override this written statute. This rigidity protects DPEC's judicial resources from being flooded with minor disputes, but it actively frustrates individuals who feel the lower system has failed them. Escalating a tribunal case to the apex court is a legal dead end that ignores the required mechanics of the justice system. The exact same legal logic applies when the Ministry of Justice's digital registry breaks down. Self-represented litigants frequently argue that a state website deleting their file constitutes a coordinated breach of their constitutional rights. This graphic shows how Section 69 of the Senior Courts Act categorizes court events. It draws a hard line between a formal judicial decision and an administrative event. An IT glitch or a portal deletion is classified entirely as an administrative error. You legally cannot appeal a computer error to a panel of Supreme Court judges because no judge actually made a ruling. Spending your time framing a digital glitch as a massive constitutional crisis distracts you from fixing the actual paperwork. While a digital deletion feels like a systemic denial of justice, the legal framework treats it as a localized housekeeping issue that requires a localized fix. That localized fix happens back down in the administrative legal infrastructure. The immediate step is to abandon the appellate strategy and gather cryptographic proof that you made the attempt to file. You need to pull your bank payment receipts, capture the system logs, and save any automated email confirmations. You then use that evidence to file an urgent interlocutory application at the local high court registry. This procedure gives a local judge or registrar the authority to use their administrative oversight. They can manually backdate and formally accept the dropped document. It requires swallowing your pride, dropping the skate harassment conspiracy narrative, and executing strict procedure. This tedious digital housekeeping guarantees the preservation of your legal timelines and keeps your lawsuit alive. This matrix outlines the return on investment for both strategies, the Supreme Court sledgehammer versus the local registry fix. Demanding apex review for a minor administrative error triggers a proportionality audit of your legal strategy. The system categorizes you as a disproportionate litigant, resulting in rapid dismissals and financial cost orders levied against you. Executing the local fix means you are operating correctly within the 2026 procedural efficiency mandates. You save thousands of dollars, avoid judicial censure, and effectively force the registry to process your case. Escalating a procedural annoyance into a battle over sweeping principles ensures you lose your actual case at the lowest level. The reality of navigating New Zealand's modern justice precinct comes down to understanding exactly what the courts are designed to do. If you treat the courts as a soapbox to broadcast grievances about government IT failures, the law will shut you down at the gate. But if your goal is to win your dispute, you absorb the frustration of the glitch and simply refile the paperwork locally. Trading the drama of a constitutional battle for unglamorous procedural compliance is the required price for protecting your rights.
Don't go to the top, stay local now. That's the only way you'll win